Patrolling Australia's massive northern coastline is a difficult, time-consuming, expensive task, often involving the Defence Force, Australian Border Force and private agencies on the sea and in the sky. In the late 1980s, the Commonwealth called for tenders for companies to provide aerial surveillance of the northern coastline. Amann Aviation was awarded the contract. They began spending money to acquire the correct types of aircraft and to have them fitted out properly for surveillance work. Unfortunately, things didn't go entirely to plan, and by September 1987, when they were supposed to be up and running, Amann still didn't have all the aircraft they needed. At the same time, the Commonwealth was coming under pressure from the previous contractors, Sky West, to dump Amann and give the contract back to them. The Commonwealth decided that's what they were going to do. They gave notice to Amann Aviation that they now considered the contract to have been terminated. The notice they gave would have been a perfectly proper way to terminate the contract under the normal common law of contract. However, there was a problem. Justice Beaumont, the first instance judge, described it in this way. By clause 2.24 of the contract, there was laid down a procedure for the cancellation of the contract. The procedure under clause 2.24 required the Commonwealth, in a case of breach of the contract, to give Amann a notice requiring it to show cause why the contract should not be cancelled. It was then a matter for the Commonwealth to decide whether it would or would not cancel. However, clause 2.24 laid down an exclusive code in the field of termination so that the Commonwealth no longer had any power to terminate on common law grounds. The Commonwealth could only proceed, if at all, under the show cause provision. Because the Commonwealth didn't follow the rules set out in the contract, its attempt to terminate was invalid. This means the Commonwealth had repudiated the contract, so was no longer ready, willing and able to complete it, and so Amann Aviation was entitled to damages. This case is actually authority for a number of points, but for this video, what we learn from this case is that two parties to a contract are allowed to agree to rules for the termination of their contract, and if they do so, those rules will be binding between them.